bother us about definitions about law, definitions about culture, because I assume, and I think that presumption is not rebuttable, that everyone in this room knows something about law and something about culture. So I'll just go straight to the challenges as it relates to Nigeria. Like all African countries, Nigeria, the word Nigeria is a creation of the colonial. There was no such word before the colonial came in 1862 through Lagos. They came in through Lagos, in which Oba Dosumu handed over his kingdom, to the British sailors that came in front of his palace in Idugoro. And from Lagos, the inroad came to all other parts of Nigeria. And in 1900, there was a legal structure to bind everyone. And in 1914, there was the amalgamation of both the northern and southern protectorate. And that's how we have the word. And the word Nigeria was given to us by the girlfriend of the Lord General, Flora Shaw, who later became Mrs. Frederick Lugard. And that name has stuck. Nigeria has legal pluralism like every other African country or colonized state. So we have the common law, we have the Islamic law, and we have the customary law. And of course, they are like that in the order of hierarchy. Now, what are really the challenges? One, recourse to English laws where rules of indigenous are objectionable or inadequately developed. You find that, just like Anthony said, when judges are confronted with a dilemma, what they intend to do is to resort to English law, to be able to resolve the dilemma. Then recourse to customary law in cases of injustice, and I put the injustice in quotes, has also concealed the need to effect necessary modification of the exotic rules of received English law. Because English law has been portrayed as the best, and it doesn't have any flaw in any way. But of course, we do know that some aspect of English law does not tally with the lived reality of the average African person. And then we have the choice of law rules in themselves, unsuitable in modern times in the face of misapplied or practically ignored by the courts. And I could give example. We're a bit different in Nigeria. You find that everyone who gets married in Nigeria first will do a customary law marriage, in which the families will get together. And then they proceed to the marriage registry. That's another form of marriage. And then they go to the church. The churches also grant marriage license. So you find that an individual, a couple, have 3 levels of marriages like that. And if they are Muslims, they do Islamic marriage as well. So you can see the problem when there's an issue of divorce. Then there's an issue. Even if you divorce the civil law marriage, what about the Islamic law marriage? What about the customary law marriage? And so on and so forth. And then, of course, we have the repugnancy doctrine, which is trying to measure African culture through the lens of the English legal system or English values. And so they say, we'll look at that, we'll see if this culture is not repugnant to natural justice, equity, and good conscience. And if in any way it's repugnant to those 3 or one of those 3, then that custom goes. Then the need for codification of our customary laws. Nigeria is a diverse country. We have more than 250 tribes and many languages. And of course, some people, some ethnic nationalities within Nigeria have been able to codify some aspects of their culture, but this has not been able to apply to every ethnic nationality. Then we have the challenge of existence of different systems of court. We have the common law courts, we have the Sharia court, and we have the customary court. And all these are in the Constitution. And then we have the challenge of the judicial system itself. The average Nigeria cannot relate to the common law system, because it's adversarial in nature. And then we have the problem of language. A country where about 60% are illiterate, and in the court, it is English. English is the lingua franca. So you find that litigants are spectators in the court, when two lawyers are slugging it out. And they don't even really understand what is happening. And at times you find that maybe after the proceedings and the two lawyers decide to shake hands, you find the litigants angry. How could you shake hands with my opponent? So the problem of language really exacerbates that. And then what are the conflicts? The diversity of the Nigerian peoples and laws. Customary law is not the same in every locality. And so that diversity, which most people tell us should be a strength, is also one of the conflicts in law and culture in Nigeria. And then we have the superimposition of English laws and statutory enactment. In fact, the English law, their holy grail, you can't say anything against them. Even the one that is not working, like bigamy. Bigamy is in the statute book, but except the Lagos state, which has struck out bigamy, all other states in Nigeria still have bigamy in their laws. And then we have majority of the people of Nigeria are subject to the primacy of culture, including the speaker. Because you see yourself first and foremost, if I meet you in Nigeria and you're talking to me, if you ask me, where are you from? Say, I'm from Abonima. I'm a Calabari woman. I would never say I'm a Nigerian. So my culture, I see myself, and most Nigerians, if not all Nigerians, see themselves primacy from the lens of the culture. Then the differences in the rights enjoyed under English law, Islamic law, and customary law. Of course, that's so evident. There are different rights enjoyed under those systems. And that's why when Anthony was talking, I couldn't even I understood what he was saying, but I can't really relate to him because I'm a Calabari woman and I know I can inherit in Calabari land. I'm not an Igbo woman, So you find the differences, and then the differences between the various customary laws within Nigeria. Now, let me just quickly go to the adaptation in a global village. How have law and culture adapted in Nigeria to the global village? I'll first talk about human rights. Most people always think that law and culture, and when they say law, they look at the customary law, that it doesn't have anything to do with human rights. But I will say here that Nigeria, in a way, have been able to adapt, even with the culture, to that global village in some aspect, not in every aspect, at least in human. We have the National Human Rights Commission, and we have the two cases that really brought us to the international sphere. That is Amina Lawal and Safia Tonga, the Sharia cases immediately after we came into democratic space. And then we have the issue of environmental degradation. Of course, as like all other states, in political states in the world, we also have the National Environmental Standards Regulation Body. But more importantly, we find that women in communities, especially in Niger Delta, where I come from, have been able to take the vanguard of environmental protection, especially with the oil multinationals, to press for the need that they must respect best international practices. Then I also look at the issue of information network. Though I'd said earlier that we don't have codified laws and so on and so forth, but we've had intellectuals that have written in some aspect of our culture. For example, we have T.O. Elias, who have written on the nature of African customary law, which is a masterpiece he wrote in 1962 through Manchester University Press. We have Family Property Among the Yorubas by G.B.A. Koka. And in history and social sciences, we have J.F. Ade Ajayi, we have Obaro Ekime, we have Peter Bodering, disputing, with the whites, the colonialists, that we do not have history or that we cannot philosophize, and all this have been brought out to show to the world that we, in a way, we do have something that people can be proud of, So we've been able to. We still do have our problems, but at least we've been able, in a way, to conform to the international. Of course, we have crime reduction, like every other. Crime is a global problem, but we have the Anti-Terrorism Act, just like the UN and regional charter. So we are trying to adapt to the global village, despite the fact that we may not be all that powerful in quotes, but in a way, our law and culture has not really made us not to be able to do such. Then I talk about women's rights, because women's rights, when we're adapting to a global village, I try to think of what are the key facts in the global village. And those are the things I've mentioned: human rights, environmental degradation, information network, crime reduction, and women's rights. Nigeria have been able to conform to those areas. And then I'll conclude, say, law and culture are really no strange bedfellows. Nigeria, though a creation of colonialism, have been able to show that law and culture, despite its challenges and conflicts, can adapt to a global village. There are still areas that need attention in order for the global village to take Nigeria very seriously as a good global citizen. The issue of corruption, gay marriage, and good governance top the list. Nevertheless, with all Nigerian shortcomings, it can be said that law and culture in Nigeria is adapting to the global village. Thank you.